What's up, everybody? We have the official motion for new trial filed by Alec Murdaugh's team. Some of the details we've heard before as far as the factual background, we'll still read through it, but we're really going to focus on the legal standards, what they have to prove, whether or not we think they've proved it, whether or not we think there's going to be a hearing, an evidentiary hearing. This was filed a couple days ago, I think maybe the end of last week, Friday, something like that. But I figured now was the time to actually read the entire thing. I don't think we read, every word or every page of it before when it was part of the motion for the appellate court to pause the appeal, kick this back to the trial court, which was granted. This is the official motion for new trial. So I figured we'd read through it together. It's like 14 pages, not that long. We'll see what the factual background is. A lot of it focuses on Miss Becky, obviously. We're going to look at the legal standard and see what we think the outcome is going to be. And I want to know from you all what you think the outcome is going to be as we read through it. So let me know in the comments if something pops out to where you're saying, yep, he's definitely going to get an evidentiary hearing. Yep, he's absolutely going to get a new trial, or no way, it doesn't make sense to me. Murdaugh, through his counsel, hereby moves the court for a new trial after discovering that the clerk of court tampered with the jury by advising them not to believe Murdaugh's testimony and other evidence presented by the defense, pressuring them to reach a quick guilty verdict, and even misrepresenting critical and material information to the trial judge in her campaign to remove a juror she believed to be favorable to the defense. So a lot of this is going to be exactly the same, I guess, as what we've already read, but I haven't read it yet, so we're going to read it together here. But I do want to focus on, because there's been a lot of discussion on what the legal standard is. Do they have to just show that she talked to the jurors? Do they have to show that she actually changed the verdict of some jurors? And that's what I really want to get into eventually. During the trial, she instructed jurors not to be misled by evidence presented by Murdaugh's defense, told jurors not to be fooled by Murdaugh's testimony, had frequent private conversations with the jury foreperson, court-appointed substitution for the foreperson, the jury elected for itself at the request of Ms. Hill. So, I mean, that alone, just if those statements are true, that she told them not to be misled or fooled by Murdaugh or his lawyers, and that she wanted to change the jury-selected foreperson to a court-appointed selected foreperson that she was having multiple conversations with, that to me is pretty bad. Now, will it end up being true? We'll see. During the trial, she asked jurors for their opinions on his guilt or innocence. She invented a story about Facebook posts to remove a juror she believed might not vote guilty. She pressured the jurors to reach a quick verdict, told other people this shouldn't take long. She did these things to secure a book deal for herself and media appearances that would not happen in the event of a mistrial. Disagree with that. I think she still could have written a book and gotten media appearances if this ended in a mistrial. She betrayed her oath of office for money and fame. Once these facts are proven, the law does not allow the court any discretion about how to respond. It must grant a new trial. So I do kind of agree with that if what they said above is true, then the court has to grant a new trial. But is that actually what took place? Or did she just talk to them? Could some things she have said been misleading or misunderstood? Because that does leave open some gray area. And that's why I think the legal standard is going to be important to dig into when we get there. He was indicted for these crimes. Court was not held on the 20th, which was President's Day. After they returned, she began to enter the jury rooms often. So basically, it wasn't until then. As the defense began its case, y'all are going to hear things that'll throw you off. Don't let this distract you or mislead you. These are quotes from the affidavits filed by the jurors, which we've read. Additionally, Ms. Hill and Jury 26, the new foreperson, on multiple occasions went to other rooms, had private conversations. Sometimes they'd go into the jury's room, single occupancy bathroom together. I mean, that alone would be really weird. And kind of regardless of what their conversations were, I'd be uneasy if I was the judge in this case, if that was actually happening and multiple people saw that happening. And I'd be interested if Ms. Becky or that other juror deny it. But again, that's why we need to have an evidentiary hearing. Foreperson never said anything about the content of those conversations. Hill instructed jurors they could not ask the foreperson about those conversations. And again, jurors, as you see here, not just one juror. So that means multiple jurors are going to corroborate that. 2 days later, and continuing through the next day, Murdaugh testified. Before he began, she told jurors not to be fooled by what's presented by Murdaugh and his attorneys. Also instructed them to watch him closely, look at his actions, look at his movements. Now that watch him closely, I mean, I still don't think she should be doing any of it, but watch him closely does not exactly make them think that he's guilty or innocent. They should watch him closely. Immediately after he testified, the foreperson told the jury Murdaugh was crying on cue. She also criticized the former foreperson for handing Murdaugh a box of tissues when he was crying, because that's what the defense wants us to do. So a lot of discussion going on when they weren't necessarily supposed to be discussing the case, which is not necessarily, an appellate issue, but not what they're supposed to be doing. They're not supposed to discuss it until they start deliberations. The next day, Ms. Hill told Judge Newman about a Facebook post, and that was to get rid of the egg juror. She could not produce a copy of it. A subordinate employee in the clerk's office, Lori Weiss, discovered that the post was taken down and replaced with an apology post, which we've read. The apology post states that the initial post was already deleted, so it would have been impossible for Ms. Hill to see the post on February 24th. All very weird circumstances, but again, does not look great for Ms. Hill or for the court. Mr. Stone gave a sworn statement that said no such post exists, again, which was attached, and we've read. Mr. Murdaugh has obtained an authentic download of the entirety of Mr. Stone's Facebook activity, which confirms he did not post the apology and that he, in fact, never posted the Waterboro word of mouth Facebook page during the trial. So where did Ms. Becky get it? And in this argument, they're saying she invented it to get rid of a juror who might not vote guilty. A person who made the apology is unrelated to Tim Stone. He lives in Georgia, different profile picture, never posted anything about the Walterboro word of mouth. The original post Ms. Stone apologized pertained to an argument about Ms. Stone's wife's aunt sticking her nose in his business. He felt terrible about the post, deleted it, and posted an apology. Again, it was a totally irrelevant post to the Murdaugh trial that this other Tim Stone posted an apology for and deleted, but none of it ever had to do with this juror discussing things with her ex-husband who she had restraining orders out against. Ms. Hill questioned this juror about the fictitious post. She told her someone had emailed her stating her ex-husband posted on the Walterboro word of mouth page that she'd been drinking with her ex-husband and expressed opinions about guilt or innocence when she was drunk. The juror told Ms. Hill that it never happened and that she hadn't seen her ex-husband in 10 years. She asked to see the post, but of course, Ms. Hill wouldn't show it to her. Ms. Hill asked the jury whether she was inclined to vote guilty or not guilty, and she said she had not made up her mind yet. So it's not that she was going to vote not guilty, but it's that she didn't say she was going to vote guilty, according to Murdaugh's team. That's their argument. Later, Ms. Hill told juror 785, which is the egg juror that fled, met with Mr. Stone. He confirmed he made the post. This is also a fabrication by Ms. Hill. Now, the point is going to be, I think there's going to be multiple people pointing the finger at each other saying they're not saying the truth. Obviously, we don't know how Eric Bland's jurors that he represents are going to fit into all of this. Seems like they're not going to corroborate the story by the jurors that are working with Murdaugh's team. Obviously, Miss Becky can't admit to most of this, like lying about saying Sled went and talked to Miss Stone, but that's easy to fix just to say, I never said that. And then it's just this juror's word against hers, unless other people were there. I mean, that's what I expect to happen. We'll see. Miss Hill also said that she would reinstate a restraining order against Miss Stone, which is something Miss Hill did not have authority to do. Later that day, Judge Newman examined the issue in camera. He described her interactions with Miss Hill regarding the Facebook post. She denied making any inappropriate comments on the case to third parties. She stated she wanted to hear closing arguments before forming an opinion on the guilt or innocence. After she was dismissed, Judge Newman said, "Oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and bringing it to me. He was right to be concerned." And again, we take this and we can apply it to the fact that once Judge Newman now finds out, if true, Ms. Becky was meeting with a new foreperson in the bathroom alone. Judge Newman finding out. Sled never saw it. Did Miss Becky say that Sled went and talked to Mr. Stone and he confirmed it? Was she making things up? Was she lying? Was she fabricating things? Was she telling jurors that Murdaugh was going to try to fool them or he was crying on cue? He's going to be none too pleased with that either. The next day, the jury visited Moselle. During the visit, Ms. Hill walked off with the foreperson in her book. Ms. Hill vaguely hints at communicating her opinion on Murdaugh's guilt to the jury during the visit to Moselle property. And here's the excerpt from the book. While the jurors viewed the Moselle property, we all could hear and see Alex's story was impossible. We all. Some of us, either from the courthouse, law enforcement, or jury at Moselle, had an epiphany and shared our thoughts with our eyes. At that moment, many of us standing there knew. I knew, and they knew that Alex was guilty. Some drama, but also towing the line of impropriety because knowing by someone's eyes doesn't necessarily invoke anything inappropriate on Ms. Hill's behalf, in my opinion. So this alone would not be enough. That day, Judge Newman also had an in-camera conference regarding the tenant coworker email in which he decided to revisit the Facebook post. The court said, okay, well, let me see what Becky is talking about. I wanted to revisit the Facebook post you mentioned initially. Ms. Hill said, right. Court said, that's Becky Hill, clerk of court. Can you tell us about the Facebook post? And Moselle said, yes, I think it was Friday evening. Just for a brief moment, I perused Facebook, got on multiple word of mouth and saw where someone had said that, well, it was the ex-husband of a juror. And he said he noticed his ex-wife was saying that she was on the jury and saying stuff about how her verdict was going to be and that he was the ex-husband, but she was known for talking way too much. And then I just kept scrolling because that was enough for me. I've gotten enough. How did you determine who he was talking about? When I heard there was an email on Monday, I figured the two went together if it was true. Well, she's confirmed she has an ex-husband who she has 3 restraining orders out against. So, right. So then we looked on Monday after you told me to try to go back and look for it, and we couldn't find it. But then we found out his name and we found the post and printed it out. And that's where he said that he pulled something up, but that he had deleted it at the time, that he had put some stuff out there that wasn't nice. He said he got drunk afterwards, something about the devil. Did he say it was Satan in it? Didn't he say it was Satan in it? Satan was in it, yes. In all the details, yes. All right, made me do it. The court, I just wanted to have that on the record. You're reading a Facebook post by the ex-husband who said it, of course. You haven't talked with him, so you don't know where he got this information from. I don't. I can find it, though. Well, turns out it wasn't the ex-husband. But Ms. Hill never saw any such Facebook post. She made it up. Further, she knew the apology post was not posted by juror number 785. Juror number 785 showed Ms. Hill a picture of her ex-husband, which is not the Facebook profile picture of the Mr. Stone post about Satan. So this is about as bad as it gets because they searched the real Tim Stone's Facebook in its entirety and it wasn't there. They figured out what post the wrong Tim Stone that wasn't connected to the case. They figured out what his apology was connected to, which was a post that was before Miss Becky said she ever got on Facebook. It was deleted and had nothing to do with the Murdaugh case. So we have found, 3 kind of answers: the apology post by the wrong Tim Stone, the actual initial post by the wrong Tim Stone, and the entirety of the Facebook account from the right Tim Stone that doesn't have any of these posts that Miss Becky's talking about. So how did she even come to this mistake if she didn't make it up? That's going to be an interesting argument made by Murdaugh's team, I think. The next day after the verdict, juror 75 received a call from her ex-husband. She didn't answer. The call upset her because Ms. Hill's lies had led her to believe he was posting on Facebook, might be stalking her. She asked to speak to Ms. Hill. She told Ms. Hill she was scared. Ms. Hill told her that the Murdaughs probably got to him, meaning her ex-husband. Ms. Hill once again asked her opinion regarding Murdaugh's guilt. Juror said she told her that Creighton Waters' closing was good, but she still had questions. Ms. Hill asked what questions she had. She replied, no murder weapon was found. Ms. Hill asked, well, what makes you think he's guilty? And she said, Paul's video at the dog kennel. Ms. Hill told the juror that everything that the Murdaugh has said has been lies and that I should forget about the guns. They will never be seen again. She's saying this under oath. While she was a juror, getting these kind of statements from Ms. Hill is totally inappropriate and, in my opinion, would rise to the level of necessitating a new trial. We'll see if they end up being true or if the judge finds them credible eventually. Ms. Hill then asked juror number 785 about the views of the rest of the jury, telling her if the 4-person would just go in and ask for a raise of hands, it would be over and done with. Everyone needs to be on the same page. 785 went to the jury room. 10 minutes later, was excused from the jury. In open court, immediately after her excusal, she asked Judge Newman if he had spoken to the clerk, referring to the conversation earlier that morning with Ms. Hill. Judge Newman responded that I have not spoken with her today and that it is totally independent of any conversation regarding her ex-husband, apparently misunderstanding her question to refer to the issue of the Facebook post. When the jury began deliberations that evening, Ms. Hill told them this shouldn't take long. If they deliberated past 11 p.m., they'd be taken directly to a hotel. None of them were prepared to stay overnight. Additionally, smokers on the jury asked to be allowed to take some breaks they had previously been allowed to take during the 6-week trial. Ms. Hill told them they could not take breaks until deliberations were complete. So Ms. Hill's the one that didn't let them take breaks. They were able to take breaks in the past. I know Eric Bland, I think, posted about this. Somebody sent it to me where he doesn't think that that's a big deal. And, it's not an absolute right to be able to take smoke breaks. I have literally never had a juror ask to take a smoke break and any court or lawyer object to it or say no during deliberations or otherwise. We do not want to make jurors uncomfortable. We don't want to make them make bad decisions for any reason. It would be totally inappropriate to not give them 5 minutes to go have a smoke break. I mean, they're allowed to take breaks whenever they want, literally throughout the trial. If they're uncomfortable, they need to go to the bathroom. They need to stand up because their back hurts. They need to make a call to a nanny, whatever it may be. There were 6 smokers on the jury. So that affected a large number of the jury. Ms. Hill told jurors that after the trial, they would be famous and predicted that the media would request interviews with them. Ms. Hill even handed out reporters' business cards to the jurors during trial. Horrible. Come on. We can't do stuff like that. This is why we can't have nice things. Juror 578 took this to heart and made an appearance on Good Morning America the night of the verdict, which is why on the day the jury began deliberations, he wore a suit coat for the first time during the trial. After the verdict and immediately before sentencing, Ms. Hill pressured the jury to speak as a group to reporters in front of the network news show. She traveled with the jurors to New York City and then appeared on the Today Show. She got her book deal. Her book, Behind the Doors of Justice, was released on August 1st, 2023. Now, they do lose some pack with that punch because it was not a normal book deal, as we've already kind of discussed. A last point about Ms. Hill's efforts to promote her book shows her dishonest efforts to profit from the trial continued well after the verdict. A film crew negotiated a contract with the Colleton County Sheriff's Department to use the courthouse bailiffs to provide security while they filmed the documentary at the Colleton County Courthouse when it was closed for Confederate Memorial Day on May 10th, 2023. The film crew had previously recorded an interview with Ms. Hill. On May 9th, Ms. Hill sent a memorandum to the film crew purporting to be an addendum to the contract. In it, she demanded that the film crew pay Colleton County a fee of $1,000 per day for use of the courthouse facilities and made a nonsensical statement about not having authority outside South Carolina that reflects a failure to understand the choice of law clause in the contract. Then she bizarrely and added a handwritten demand, also in exchange for the use of the likeness of Rebecca Hill in an interview. A minimum of a 5-second video and audio clips will accompany the usage of the first reference. The book cover for the book, Behind the Doors of Justice, The Murdaugh Murders, will be shown, and audio will include Becky's introduction as clerk of court for Colleton County and author of the book. The film crew ignored her addendum as the contract had already been executed. But like her jury tampering during the trial, it was an attempt to violate South Carolina code, which provides no public official, public member, or public employee may knowingly use its official office, membership, or employment to obtain an economic interest for herself. Oopsies. She tried to fix it with an addendum after the contract was already signed, but that's not how it works. So again, just more missteps from Becky Hill. The legal standard. A defendant in a criminal prosecution is a constitutional guaranteed a fair trial by an impartial jury, and in order to fully safeguard this protection, it is required that the jury render its verdict free from outside influence. When the defendant presents a credible allegation of communications or contact between a third party and a juror concerning the matter pending before the jury, the defendant has an entitlement to an evidentiary hearing. So basically, they just have to present a credible allegation, and I think affidavits from all these jurors is absolutely enough to be a credible allegation, and therefore I personally think they are entitled to an evidentiary hearing. Right now, not necessarily a new trial, because I want to hear what Eric Bland's jurors have to say. I want to hear what Becky Hill has to say if she testifies and doesn't plead the fifth. And I want to hear what these Murdaugh jurors say actually in their own words, not in an affidavit that may have been prepared or helped prepared by Murdaugh's attorneys. This court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. The defendant proves the alleged contacts occurred. The prosecution bears the burden to show they were harmless. So the defense has the opportunity to prove actual bias, but once they prove the alleged contact occurred, the prosecution then bears the burden to show it was harmless. In a criminal case, any private communication, contact, or tampering directly or indirectly with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial if not made in the pursuance of known rules of the court and the instructions and directions of the court made during the trial with full knowledge of the parties. The presumption is not conclusive, but the burden rests heavily upon the government to establish, after notice and hearing of the defendant, that such conduct with the jurors was harmless to the defendant, which seems to me to believe that you would have to show that there was some kind of harm. Because if the contact was harmless, then it's fine. And that's kind of where I felt the whole time, is that regardless of whether or not it would be a big deal for lack of a better term, or harmless, they need to get this evidentiary hearing. Then once we get to the evidentiary hearing, the judge has to parse through the gray area of, was this contact enough to make the trial unfair? I don't think it has to rise to the level of changing their vote from guilty to, or from not guilty to guilty. It just has to have some kind of an existential effect on the jurors, the way they viewed the evidence, the way they walked through the case. To me, and again, this is a big if what Murdaugh's lawyers are saying and what the jurors they have affidavits from are saying is true, then I think there should be a new trial. I know people are going to disagree with that, but I think there's a way that the AG's office and Eric Bland can cast a lot of doubt on some of these arguments. The presumption is even stronger where the contact was made by a court official, as it should be, where there was private communication of the court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained. A new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the juror, have affected the verdict. So that means, how's the weather? Watch your step. It's a little muddy at Moselle is fine, but you see how what Murdaugh is saying is impossible at Moselle? Even one statement like that, there must be a new trial. A state official, Becky Hill, the elected clerk of court, had extensive private communications with members of the jury during trial. Allegation is supported by sworn affidavits of the jurors and a witness to jury interviews, testimony at an in-camera proceeding, and other evidence, including Ms. Hill's own book. The court, therefore, must hold a Remmer evidentiary hearing. If the allegations are proven at the evidentiary hearing, then under binding appellate precedent, the court must grant a new trial unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. The subject matter of Ms. Hill's communications was the evidence being presented at the trial by the defense. These improper comments and efforts to influence the juror's verdict vitiated the sanctity of the jury's deliberation and Murdaugh's sacrosanct right to a fair and impartial jury. Therefore, the court must grant a new trial if the allegations are proven. Even they say, if the allegations are proven. So they need the opportunity to prove them in an evidentiary hearing. In a 6-week trial, people will talk when they should not. They will say things they should not say. Mistakes will be made. The participants in a trial are fallible human beings. Lawyers combing the proceedings after the fact will always find they made mistakes and errors. If that were enough to force a redo of the trial, no verdict would stand, and trials would be repeated forever. To avoid that, the courts properly strain to find what mistakes made during the trial are harmless, meaning they did not change the result. Interesting language. But the issue now before the court are not the ordinary and inevitable mistakes that occur in any trial. The issue here is that an elected official engaged in intentional misconduct, deliberately violating a defendant's constitutional right to a fair trial before an impartial jury to secure financial gain for herself. Actually, to me, the reason she did it doesn't even matter. The fact that she did it, if she did it, and if it was intentional, and this was the conduct she engaged in, then he needs a fair trial. The fact, and we don't need to quibble about whether or not she made money or spent money on making this book. Where a state actor engages in a private communication with the jury about the merits of the prosecution, the verdict is impossible to sustain. For example, in this case, a bailiff told a juror in a murder trial that wicked fellow, he is guilty. The Supreme Court of Oregon held the statement did not require a new trial because it was not shown the statement prejudiced the outcome of the trial. The United States Supreme Court reversed that decision. That is a holding that is binding on Judge Newman. So they reversed, holding the evidence developed against a defendant shall come from the witness stand in a public courtroom where there is full judicial protection and the defendant's right of confrontation, of cross-examination, and of counsel. And we have followed the undeviating rule that the rights of confrontation and cross-examination are among the fundamental requirements of a constitutionally fair trial. So basically, they should have had the right, in Murdaugh's case, to cross-examine Miss Becky and confront her and say, you're trying to get a book deal, blah, blah, blah. That's why you wanted to be guilty so bad. If she was going to testify that she had some relevant and credible information that proved Murdaugh was guilty, as opposed to her just being able to say stuff, because what she's saying is not likely to be admissible in any court of law in the United States. In this case, the court has declared on the record that the verdict that the jury, reached is supported by the evidence, circumstantial evidence, direct evidence. All of the evidence pointed to only one conclusion. That's the conclusion the jury, reach now. The court has, I like how they post video of the trial from YouTube. The court has therefore foreshadowed the outcome of any harmless error analysis. But the rule for deciding whether to grant a new trial is not whether the court believes the outcome of the trial would have been the same had Miss Becky's jury tampering not occurred. If that were the case, the court would sustain a guilty verdict even if she coerced the jury to vote guilty at gunpoint, because in the court's opinion, all of the evidence pointed to only one conclusion: the guilt of the accused. If the strength of the evidence against the accused, in the eyes of the court, excuses deliberate jury tampering by a state actor, the result is directed verdict for the prosecution, a structural error. What they mean there is, doesn't matter what Judge Newman thinks, and I think Judge Newman would agree with that. Any trial court judge, it doesn't matter whether you think they're guilty or innocent. Whatever the jury decides is what the outcome ends up being. Sometimes judges agree, sometimes they don't, but regardless, they are not the fact finder at a jury trial. But in this case, Judge Newman's comments were so strong that the court's saying, even with your feelings, Judge Newman, which you made very clear on the record and in this video, it doesn't matter because of the state actor's intentional jury tampering. That cannot be the law. And I agree with him there. God forbid you get a bad judge. Scalia from the Supreme Court noted that even if the judge certainly reached the right result, a directed verdict against a defendant would be per se reversible, no matter how overwhelming the unfavorable evidence, because the very premise of a structural error review is that even convictions reflecting the right result are reversed for the sake of protecting the basic right. A lot of you probably aren't going to like that, but a lot of you probably will, because we have to protect people's rights so innocent people don't end up in prison. And sometimes if a guilty person skates by, then I don't want to say so be it, but it does happen in order to protect the rights of innocent people. Instead, the law requires the subject matter of the communication to be harmless, clearly harmless. Asking the jury what it wants for lunch is clearly harmless. Telling it not to believe the defendant when he testifies is not. That's a great microcosm of the entirety of what the judge has to decide in this case. Was she just asking for lunch orders, or was she telling him not to believe Alec Murdaugh? Our Supreme Court recently made this point in State v. Green. And Green, during jury deliberations, a juror asked the bailiff what would happen in the event of a deadlock, and he responded the judge will likely give them an Allen charge and ask them if they could stay later. The Court of Appeals held that the bailiff's comments were presumptively prejudicial because of his official position, but that the state rebutted that presumption by showing that for various reasons, the remark did not in fact influence the outcome of the jury deliberations. So even something as seemingly harmless as that, where the bailiff was probably right and he didn't tell him to vote one way or the other, but just basically mentioned an Allen charge, even that was potentially enough to be a reversible error. The Supreme Court affirmed but modified the decision to correct the Court of Appeals' reasoning. The communication was not presumptively prejudicial because the subject matter of the communication was harmless. I agree. Bailiff's actions here, though improper, did not touch on the merits, but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never materialized. In other words, a bailiff telling the jury that if it is deadlocked, the judge will instruct them to keep deliberating is improper but likely harmless because the subject matter is procedural or logistical rather than the merits of the case. I agree. Telling the jury not to believe the defendant's defense or his testimony when he testifies regards the merits of the case. I agree there as well, if that actually happened. Ms. Hill's extensive, deliberate, and self-interested jury tampering far exceeds the simple bailiff mistakes that forced a retrial in Cameron, where a bailiff's misleading response to a jury's question about sentencing options compromised the jury's impartiality because it left the impression that their verdict could not affect the trial court's sentencing discretion. And that obviously is a different case where the jury was actually starting to talk to them about sentencing, which could affect how they think about guilt or innocence. Unlike the honest mistake of bailiffs in those cases, Ms. Hill had many private conversations with jurors about the merits of the case. She asked jurors about their opinions of guilt or innocence. She instructed them not to believe the evidence in the Murdaugh defense. She also told them not to talk to each other about their conversations, right? Which in my mind shows that she knows she shouldn't have been doing it. She instructed them not to believe the evidence presented by Murdaugh's defense, including his own testimony, lied to the judge to remove a juror she believed might not vote guilty. She pressured jurors to reach a guilty verdict quickly so she could profit from it. Each of these actions violated her oath of office, her responsibility to her citizenry, and the judiciary of the state, and Mr. Murdaugh's constitutional right to a fair and impartial jury. The law applied to these facts requires a new trial. For the foregoing reasons, Murdaugh respectfully submits the court must hold an evidentiary hearing to receive proof of the facts stated above. When those facts are proven, the court must grant a new trial. So I kind of agree with that last statement. I think the court must give an evidentiary hearing, and if they prove the facts, it's got to be a new trial. Will they prove the facts? I don't know. What do you guys think? Let me know what you think. The facts apply to the law as stated here. Do you think an evidentiary hearing is coming? And if it does, do you think Alec Murdaugh will get a new trial? Should he get a new trial? Whatever word you think is appropriate, because words are important, put that in the comment. He will get a new trial. He should get a new trial. He shouldn't, but probably will. Whatever you think is appropriate for the verbiage, I want to see it and read it in the comments. Hit that like button on the way out if you haven't already, and please subscribe to our page. Appreciate you all joining us. That's all I've got for now. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us lawyeryouKnow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.